Good morning, good morning, good morning. So it's the end of the week, a Friday, and I'm here on time for the first time during the week, I think. We're getting ready for the fourth day of trial for Karen Reed. Good morning, Rocket Couch. Good to see you. I'm quite impressed that I'm here before 9 o'clock with myself awake. It's a good day. It's going to be good. Today, there's only going to be half a day of trial from what Judge Cannone had said. So I don't know exactly what time we'll be ending, but it probably will be around lunch. Today is scheduled the trip for the jury to actually go and see the house and also Karen Reed's vehicle. Hmm. And we are not looking at the fan this morning. We are looking at the light. And I had made a thumbnail just for you there, Couch. I'll put our star fan right front and center on the thumbnail today. Oh, it's the light. I know. Very odd, right? Oh, you did? You got the bingo card updated again? That's very nice. Thank you. I did just post the link and tagged it in both chats for us. As we're inching towards followers in Twitch, which is great. I can't wait. We'll get there. Sooner or later we'll get there. Yesterday was a little disappointing ending so soon. It was not on the schedule. It was supposed to be a full day of trial. Well, apparently there was a mix-up with the defense witnesses. I mean, the state's witnesses. We shall see. We shall see. Yesterday, I had said it was the Commonwealth who brought up the issue of experts watching the testimony. It was not. It was actually the defense brought it up and did an argument for it. And the defense was asked to think about it, and that's what the delay was. Good morning, Jean. Good grope to you. Pass one over to Couch. Sure thing. Have a grope from Jin there, Couch. I'd be happy to, Jin. We're just talking with Couch over in Twitch about how impressed I am with myself that I'm actually here before 9 o'clock. I got everything up and running too. Only took all week, but I did. Oh, Couch is sending you a good grope back there, Jean. Now we've all been groped. Hi, Turtle Moose. Oh, would you like a grope too? It's pretty lonely over here, she says. Jean, you know what to do. Good morning. See, in Twitch I can't pass coffee, but I think in I know I've got coffee going in the YouTube chat. I definitely can do that. Here we go. Oh, it's hard to see. Like they do have all kinds of different emojis over there, but they don't like when I type for certain words, I can never find anything. There you go, Couch. For you, I'll send you a flawless victory. There you go. Oh, we're back to our friend, the fan. We did have the light for a little while, which I thought was funny because I had actually used the fan on the thumbnail today. Hopefully they will be starting on time. Oh, you did find a coffee one. Ah. I probably don't have access to that one. Okay, I'll give you your privacy there, Gin, with Gin and of those three, I don't have the coffee one, but I could wave at you there. I think couch. Let's see. Nope, it won't let me. All right, there we go. Most famous fan in all of Massachusetts. I agree. And he's got a twin, like right next to it on the other side of the light. Popular. Oh, excuse me. I hope everybody has coffee, tea, something cool to drink if you like. I'm on my first cup of coffee. I was checking out the socials last night. I can't believe how mad some of those that are like what they call FKR, the free Karen Reed mode, are in regards to the clip being played of Karen imitating Peggy O'Keefe and being not so kind. They're saying it's like purposely trying to make her look bad and it has no evidential value. And I think they forget like when they wanted to put it in. I mean, it is very prejudicial, of course, but it's actually quite a brilliant legal move of the Commonwealth to be using Karen's own words against her in her trial, where she hasn't taken the stand. Well, they chose to do these actual interviews and make it public record, and it can be used. At the time, I don't think they thought there would be a mistrial. The big documentary was done while the other trial was going on. It was a behind the scenes look. All of her lawyers were involved. The three lawyers were involved. Apparently, it was Karen Reed and Alan Jackson who sold this idea. But it's put them in a bit of a position. That's very clever there, Couch. Speaking of which, that's a square now for the evidence not matching the interview. Exactly, because they're putting it in at different times. Even though the Judge Cannone is apologizing to the jury and explaining that to them, it's still going to look really odd. And it just doesn't, not go. But it is also clever that he doesn't play them first. He plays them in rebuttal. So it's the last thing that the jury's hear in regards to certain testimony. Right? The Commonwealth calls a witness. They get their part of what they want in the evidence out. The testimony, they extract the testimony they want. And then along comes the defense, and it's been pretty intense the way that they are crossing the witnesses, antagonizingly, kind of harassingly, like a hostile witness. They're treating them, everyone. And then they do their damage to credibility or the facts, in some ways try to blur it. It didn't come back the Commonwealth in rebuttal and says, shores up what they can in regards to the verbal testimony. When the witness is dismissed, they play a clip of, well, in the last two instances, would be Karen admitting to exactly what the Commonwealth was trying to get out there in direct opposite of what the defense is saying.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Well, thank you.
The host would like you to unmute your microphone. You are unmuted.
Well, thank you, court recording.
morning.
Good morning.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial.
Thank you. So good morning. I heard the council wanted to see me about something.
Yes, please.
All right, why don't you come on over to sidebar?
And just sidebar immediately. Good morning, Victoria. Good morning, book lover. I'm sorry you hit the same pink icon. I thought you were Victoria for a second there, but good morning. It's good to see you. And good morning, Puff Bunnies over there in Twitch, keeping couch company. So now you guys aren't alone over there either. It's good to see everybody. And we're opening with a sidebar right out the gate. Why am I not surprised? I'm sure you guys aren't surprised either. What do you think that they wanted to talk about first thing? Now, next Monday, we don't have on Monday so far, we don't have a full day of testimony scheduled, but we have a full day because in the morning, we have Commonwealth presenting witnesses to the stand. That is, if Bob Alessi finishes his cross-examination this morning of this witness. Fingers crossed. Then in the afternoon, we are supposed to have the voir dire of the ARCA witnesses, the experts for crime scene reconstruction that the defense wants to bring forward, that there's a lot of trouble with reciprocal discovery, and also the fact of the whole court of the candor issue from a month ago that was discovered in regards to the last trial. Problem being, and they've been put forward as independents because the FBI used them in their investigation, and then it was found out that the defense actually hired them. And so once money exchanges hands, the use of the word independent really doesn't actually meet up. Is the court vid lower quality than... I don't believe so, but I'll check. I will check the settings. I have it on auto, but it's not lower than... It's coming in currently at, it says 720 or above. Sorry.
All right.
You
Okay. Why are they now muting like that? What the heck is that? They didn't even say. I guess to bring the jury in right away. Maybe it is their camera, Puff. I'm not sure. Okay, I'm not going to timestamp it until the jury's in there and they bring their first witness in, because they didn't tell us anything that was about. If it does affect the schedule or anything with us for the day, she will say so, of course. But that was weird. I do believe they're bringing the jury in right away. Usually, especially when they said all rise, like for the jury, I'm sure that's what it was. Yeah, there's our lovely fan, isn't he? Yeah. When we first came in, Puff Bunnies, it was interesting. They didn't have the fan up there. They had the light. They had the big, the globe light with the chain. Yeah. They were trying to fool us. Judge Cannone is having strong words with the lawyers. I don't know. They asked to see her. So, I don't know. She didn't come in swinging. Are the jury aware that this has been to trial? I don't think so. I don't believe that was on the jury questionnaire. They do try to look for jury members that are not aware of the case at all. That's the same thing with them in speaking about, that Lori Vallow did a post-verdict interview with the same journalist that the Arizona Family Times, the same journalist that did the interview before when she was pro se, that was played, that we saw because it was going on while the trial was going on. Well, she did get her for the post-verdict interview, and wow, let me just go get the link for you guys for later. I was kind of surprised. The other thing I was surprised about is the misspeaking of a juror, that actually kind of the words that he used kind of implies that he may have known or found out before verdict about the children being dead. And that could be a problem. Okay. For those of you interested, here is the post-verdict interview. It's in this article up at the top. There's a link to the video of it. But I find it very interesting, if they did know, there would be a bit of a little problem. I mean, it would have been an appeal issue if Lori Vallow followed the appeal. I think we talked about this before. If she does find out about it, she probably will want it checked out. And why wouldn't she, right? This is taking a little bit longer than usual to seat the jury. Is it not? I have no idea what that was about. Just checking another feed. Nope, the other feed is also the same. So now you know what I'm going to do, right? I'm going to go to trusty Twitter and see who is reporting from the conference room, or the courtroom, rather. Let's see who's where. Day 4. Why is it so hard to find? Let's see if she's in the... Well, let's look at the Boston Reporter. Okay. Not so much. I'm not finding, what is going on here? Somebody has to say something. Nope. He's not in. Oh, man, I can't find. Every day they have a pool to find out, which reporters and all are left in the limited seating that's inside. Okay. So the ARCA hearing is not today. That's being confirmed by somebody. Okay. Well, I know that the view is scheduled. There we go. Just that it's not the ARCA hearing. This is weird. Aye. Yep. All we can do is wait for them to come back. I don't know what is so heated that we can't know about it either. What's going... it's all sidebar anyway. Let's see. Ay, ay, ay. Maybe something that happened could just be a matter of schedule or a matter of witnesses. I suspect it has something to do with ARCA on Monday, or The View. Something has happened. There's actually people just putting up pictures of the fan saying, "It's time to shine, baby. It's all you. You're on." Just cracking up. Oh, yeah. Okay. The fourth day this morning, waiting for court to start. I know today that they were going to bring the expert forward that was going to talk about the blood alcohol testing. And then I don't know if that was going to be the only witness. And I don't see anything else yet. Plenty of people covering this trial. But apparently, nobody inside the courtroom talking about what is this delay. Let's see. So, what do you guys do? You want to take odds on what it is? Maybe they just all needed more coffee. Could be it. Here we go. I know there's been some complaints from the businesses in the area about people still organizing to protest for free Canton. Oh, here they go. I hear movement.
You are
Finally.
unmuted.
Well, hello, court.
Counsel, calm down.
What? Wait. So, are you telling me she unmuted just to bring the counsel to sidebar? There's no family sitting there. Why is there no one sitting there? There normally is. What is going on this morning? Somebody took her parking spot. Very funny. Very funny. I'm sorry. Day 4. Today will be a short day with the jury going on a jury view to see the crime scene. Yup, I did read that. I'm just trying to find out why. It does look a lot less crowded, doesn't it? In the courtroom. I mean, there's the O'Keefe family. Behind the defense, that was normally full. Maybe for some reason. I don't know. We're all fans here, I know. And so now they're back up on sidebar. I don't know what they were doing before. Wouldn't put it past her to either misrepresent the jury as biased or even go out of her way to influence them inappropriately. And I'm sure you're talking about Lori Vallow Daybell. And I agree. And I also agree with you too, Puff Bunnies. It's not like she's sane or anything. Yeah. Basically, it was interesting. And of course, she feels that it's just the process. Was there trouble with the witness on Armageddon's fire? Do you know which one it is? And also, welcome. Good to have you here. Because they did dismiss Nicholas Guarino to come back, and he will be called again, of course. There's much more text messages going on. But I thought the one being called this morning, rather, was the blood analysis, the blood expert for the alcohol level in her blood. Is something with the testing of that going back and forth. Well, we shall see. But does the courtroom look a bit emptier to you guys? Like, behind the defense is where Karen Reed's family is usually sitting. Her mother and her father and everyone. It just seems a bit empty to me, doesn't it? I'm still looking for what is going on. Now that you've said trouble with the witness, I'm just looking to try to figure out what it is. Let's see. People are talking on the socials about major headlines picking up the Karen Reed story. It's not just local anymore. 2 sidebars within 18 minutes, but Judge Bev is really on her game today. Yeah, we knew what was going on. Everybody just praising the fan. Okay, I don't know. I wonder if it's about the logistics of the jury view. I still don't see anything. And we're back. Okay, are we actually going to find out what's going on?
Okay, thank you.
Oh, you absolutely did not what? I heard that. Stop. Okay, she's being quiet. She's writing stuff down and being quiet. Everybody seems kind of sullen. What is going on? Now, something is really, I don't know what this could be, but this is kind of quiet. George is quiet, writing stuff down. No one's talking. I don't know about you guys, but I feel very out of the loop right now. Very out of the loop.
All rise to executive.
Okay. Please tell me the jury's coming in this time. Hello, Light. Hello, Fan. Fancy seeing you here again. Okay. Jury being brought in.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannone, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
For the record, before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things and we were successful, so we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone nodded, affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did any of you happen to see, hear, or read anything about this case since we left yesterday? No. Thank you. Everyone said no. All right, folks, as you know, this morning we are going on a view. And a view is simply, we're going to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the view is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings. So the view that we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict. So we're going to, you've heard 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look at. While you're in the view, you're not to take any notes, you're not to take any pictures, you're not to conduct any independent investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see photographs during the course of the trial, I bet, but today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look. It's really no more complicated than that. So your responsibility is to see the place, observe it carefully, and to remember what you see. Now, during the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you. And the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
Please.
Thank you, Your Honor. Good morning, ladies and gentlemen. As Her Honor explained to you, we're going to go to 34 Fairview Road. We have some exhibits that are already in evidence quite a long time and study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little firm, concrete that comes up a little bit. I'd ask you just to note that. One thing I'd suggest is April 25th, 2025, not January 22nd, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same weather. So keep that in mind when you're looking around. When you look at the Lexus, a couple things I'd ask you to look at. There is some evidence already in photographs of the right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has been removed, so it will appear differently, and you'll later get testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height from the right rear tail light. And I'd also ask you to take note of, on the top of the hatchback, there is a project for trees. I'd ask you to look at that as well. Thank you very much.
All right. Thank you, Mr. Brennan. Mr. Yannetti?
Thank you, Your Honor. Good morning. As I told you at the start of the trial, my name is David Yannetti. I have an office in Boston and in Dedham. And on behalf of my co-counsel, we will be accompanying you on the view that you will take. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this court. You've already received in evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview, we will be pointing out certain things that we'd like you to observe. The house, second floor window to that house, the 3 front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn, the distance between the front doors to the house and that front lawn, the distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. Just size it up. To take it in. You were all selected as jurors because the parties entrusted that you would do a proper investigation of this case within this court. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation. Thank you.
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations. Also, while you're in the view, the same way you're not to take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look, okay? Those are the instructions. We will see you in a few minutes. All right, thank you. Oh, sorry, Madam Clerk has to swear in the court officers.
You could all raise your right hand, please. Do each of you solemnly swear that you will take the jury upon the premises in question and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. that you'll keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right, thank
All
you.
right, please, jurors follow me.
Okay. Oh,
Goodbye.
okay. So I just read that the media is allowed to go on The View, which was why the courtroom was so empty, because they were all preparing. So I am wondering what they're actually going to be able to show, or how quickly they're going to be coming back. And if we're actually going to have anything this afternoon. But I would suspect that if this feed cuts out completely, that perhaps we're not, you know. Jean says, you forgot to mention the shrubbery. Which one? Yannetti? Or we have some very lovely shrubbery, and he didn't even mention it. That's very rude. Very Monty Python of you, Jean. Like the shrubbery. Good morning, Teresa. Good morning. It's been a little bit weird. We went live and we waited for them, and they came in a couple of minutes. I didn't see John's dad there either. I saw the O'Keefe. It is Janet Reed's birthday today. That could be why they weren't there, or because they are because they're going to be viewing the Lexus and everything. I don't know. Like maybe they also want to follow, or there's something with the media. I'm not sure. But everything's pretty close. I don't know if we'll be hanging here for an hour or what, and then they're going to come back. And I have no idea if we're still having testimony for the rest of the morning, because this did not go the way I thought. I thought they were opening with testimony, from what I understood yesterday. But then they were at sidebar, 2 sidebars, more than 20 minutes. First thing. Yeah, I know it's weird to be up so early, isn't it? Yeah. They'll come back, enter court, and leave for lunch. That's a pretty accurate description there, and prediction, Turtle Moves. I mean, that's happened before. And it is only a half day today. So I don't know. I really don't. And just I'm going to go check the comment section of the other live feed, but they don't normally put anything up. Let's see if I can read this. I don't see any of the other banners saying anything about The View for this morning, but I'm just checking a couple of the feeds. Okay. Not that one, that's for sure. Okay. Yeah, we just give it a little search. Oh, okay. Let me pull myself up. The live stream went to the weird thing there. I'll just take that off. All right. We'll see what happens with that. I'll just give it a little view. I don't want to end the stream and start another one if there's not going to be anything. You know what I mean? Let me see what else is going on. Okay, that feed is still going. Yeah, there's just not a lot going on. I don't see any other. Wow, I don't see any other live feeds going on either, really. What does she say? Hold on. Most of them are just talking about other evidence, things like that. Yeah. And talking about different camera angles. Yep, that's it. Okay, so that's it. I would say we'll just hang out, guys, until they actually decide that this stream is not going to come back up, like if they just send it away. But everybody else has just got the fan up, and those that are restreaming, like myself, are all just talking about previous things that have happened during the case, the evidence. So, I hate to act like I don't know what's going on, but I'm going to be honest with you. I have no idea if they're coming back or not. At this point, I'm completely thrown by what has happened this morning, and I'm still impressed with myself for being on time, though. I'll tell you that. I was just like, but why? Why if we didn't hear anything? So, yeah, there we go. You think lunch and that's it? Like we're making side bets since a half day? I don't know, because how long can they actually be gone? They're all going to get on a bus and they're going to go, and it's just like we all know it was really pretty close. It take them 10 minutes there to get there. Let's see. Where are they? They're in Dedham. Fairview Road in Canton from Dedham Superior Courthouse. Let's see. Let's see how far it is. It's 14 minutes. Yep. The Superior Court is on High Street in Dedham, Massachusetts. And to go to Fairview Road in Canton is only 14 minutes away via Highway I-95. So, I mean, how long can they really be gone? Massachusetts Live has, okay, they are actually, from last year, they had up like the pictures of what everybody had saw on the view. So I'm hoping that another site will do the same, so that we can at least provide you with a link on what everybody had seen. Massachusetts Live had taken quite a few photographs from last year of the Lexus, which was at the scene of 34 Fairview, so they don't have to go anywhere else. And they got to see the house, the yard, the location of where the body was, the streets, getting there. And at the time, they had it all blocked off, like the street to turn into, so nobody else was going. And they took it there. They took pictures. They talked to them, and then they came back. So I suspect about an hour. It's so. Yup. And they had closed off the road for them all to be in there. That was last year. Okay. And apparently it just caused a bit of duress because people weren't actually able to get to their home store in the time that they were there, but they weren't there that long. In that case, they had done the jury view after the testimony in the morning, so they kind of like split it this way. I'm just finding old articles. But anyway, let me just share with you the article that I am looking at in case any of you are interested. This is the one from last year. So I think something like this will be available by tomorrow or later today. Yeah, everybody's showing the fan, Jesper. And my feed is showing just the words live stream, which is why I pulled it down, but everybody else is showing the fan. What time is it now? I have a quarter to 9:45 court time. Couch, you're an hour behind in Canada where you are, so court time is 9:45. Does anyone know if something had happened to John's dad? I'm just wondering why he isn't sitting next to Mrs. O'Keefe. There have been other days that he didn't. I do see that her son is there, and I'm sure if something happened to him, he wouldn't be there either. Well, I don't see anything, Teresa, from what I'm looking at. Mm-hmm. I'm assuming that the O'Keefes, not wanting to go by, on the run, in a separate vehicle or to watch. That's why they're sitting. It's more comfortable to sit there and wait. I really don't see anything, Teresa. I have seen that he wasn't in court on other days. It could have to do with his work schedule or things that have to be taken care of, like within the family and stuff. There have been days when I didn't see, like Paul's wife or any of the cousins. Like there's been different people there on different days. So I don't know. Yeah. I haven't seen anything in the socials about it either. Yes, it is. Here's the thing. Actually, well, no. Where they are in Massachusetts is on Eastern Standard Time. So it is actually the same time zone that I am in. Now, the Lori Vallow trial was interesting in Arizona. That was Mountain Time, but they didn't practice daylight savings time. So usually Mountain Time is 2 hours different than me, but it was 3 hours because of daylight savings, because they don't do it in Arizona for some reason. So that's why it was 3 hours. They were 3 hours behind me, which is more like Pacific. It's very confusing, but I get it. Well, Massachusetts is on Eastern Standard. They are on the same. It's the same time there as it is for me. So, like when they say court at 9 o'clock, I got to get up. The last trial was 3 hours. 3 hours behind us, and it's usually only 2 hours, but daylight savings kind of knocked it out. It's the time of year. Yeah, but that's Idaho that you're referring to. That's what I'm thinking anyway, Couch. I don't know about you guys, but I need more coffee. And I'm heading to the socials. Wouldn't it be nice if some nice journalist was on the socials posting pictures? Okay, there is a reporter that says that he's going to be listening from the road. Well, there's nothing to listen to yet. And they actually mean from the road in their vehicle. No update from anyone else. Christina Rex did actually post like hours ago about the scheduling change. And then when asked yesterday, late afternoon, if the media was allowed to go on the View, she said yes. So that's one of the, well, everything is hours and hours old. Like, nobody is posting from that I can see. I have to look for some other attorneys and some other journalists. Okay. They did expect, I will say that Law and Crime was reporting that they did actually expect to have testimony before the View. So I don't know how this affects testimony for the afternoon, except for the fact that they're not canceling any of their feeds, which means they may have heard something we didn't in the courtroom about there being testimony after the View when they come back. And this is just a big, like, delay thing, you know. Well, we could talk about other cases too. Like, there's a lot going on in the Kohlberg case right now. One of the main important things, since I'm not going to be doing a weekly update, I might as well just tell those of you that follow me that Judge Hippler has come through and said the death penalty is staying on the table, regardless of motions by the defense that should Brian Kohlberger be found guilty, death penalty should not be an option based on aggravating circumstances of his being autistic. That was one of the arguments. Yeah. But the judge is like, no. The death penalty stays on the table based on the aggravating factors of the numbers of deaths, that there were 4 murders, the egregiousness of it. You know, it was pretty violent, using a knife. He doesn't see a reason to remove it. Especially since, like, any of the testimony in regards, when they had the hearing in regards to his being autistic, they're not putting it in as mental deficient or anything like that, which wouldn't be fair anyone. Everybody knows that, like, there would have to be further testing on an autistic to actually claim such a thing, that it is a spectrum for a reason. And you just don't, you don't get that just because of the word or just of some of the tendencies, that an autistic person would be on the spectrum on different levels and in different capabilities. And without all of that being presented, there's no reason to remove it. He is a master's degree student in criminology. He has done papers, extensive college. He was a teaching assistant. There does not seem to be any deficiency there in the knowing right from wrong. There seem to be some physical things in coordination and in his physical attributes with the way he stares or uses language, but not in reasoning and or in mental acuity to dismiss the death penalty. So that's where Judge Hippler is on that. I kind of suspected he would. I'm looking forward to reading the brief, and I'll make it available to those of you in the library. And when I do the update, I'll supply a link once I find it. But the other curious thing is, for some reason, the state's witness list has been sealed. I can't get the witness list on who they're going to be bringing up. That case is coming to trial in August, Yeah, exactly. He knows murder. Yeah. Yeah, no problem, Couch. I get it. Yeah. He knows murder. Well, yeah, that's what he's on trial for sure. Well, he's going to be. Anyway, good morning, Maggie. There goes my voice again. My apologies, everyone. I'm going to have to find my spray. Excuse me while I mute 1 second to do the spray because it makes a really gross sound. Hold on. Okay, that's better. Man, that stuff works great. I have this stuff. It's called Clear Voice. It was recommended by a friend who also, has some trouble sometimes with their voice and things. Yeah. And it works great. It just, if you get it back there far enough, it just does a nice coating that helps take some of the roughness out. It won't take all of it, but it sure does make my throat actually feel better. I know. Even if he doesn't innately knows right from wrong, he should know intellectually due to his criminology school. Exactly. And that's just it. He's written papers on crime scenes, how not to leave evidence. There's a lot of back and forth about letting a lot of that in too. That could definitely prejudice a jury right out the box if he's actually doing papers and theses on, how to actually approach a crime scene without disturbing it. About the use of gloves, what to check, what not, how to secure a crime scene, which in hindsight, you can reverse all of this as to how not to leave evidence. What would law enforcement be looking for in crime scene investigators? Like, very interesting. But it is also an interesting piece of information for the defense to use, as in to counter some of the testimony of if the prosecution should bring forward his relationship with other students. There have been comments in the media that some female students at the university felt uncomfortable around him. That could be due to his stare or his mannerisms. It would give some justification. It would give some counterbalance to an argument of that nature, of like, well, he's just got that serial killer vibe, that kind of thing. So it is going to be able to come up in the trial, and just how, but it definitely wasn't sufficient to table the death penalty. Now, Idaho itself has issues with the death penalty, and when we were covering the Chad Daybell trial, we actually went over that. They have instituted the death. They've had the death penalty for a while. They were having trouble getting the drugs that are used for carrying out that sentence. One of the means of carrying out that sentence in Idaho, as other states that have the death penalty were, because the manufacturers of those drugs were making them harder to get based on pushback on what they were being used for. So Idaho cleverly instituted a second means of firing squad. And they haven't had one yet. Okay. But rather than delay those that are waiting for the injection in the death penalty, which has been, like I said, be delayed over and over again because they haven't been able to get the medications. They did have a failed injection attempt with one prisoner, which was pretty horrific. And so now they've instituted a second means of the firing squad. Has not been done in quite some time. I can't even imagine, but that's where Idaho is. And cases are still going forward. We just had a verdict guilty in Chad Daybell's case, where the jury did go and opted on death penalty. Of course, he has to go through his appeal. Everyone who gets the death penalty gets an automatic appeal. They get to file for it in a review by other judiciaries to evaluate that it can go forward. Who was the guy at the snack truck? You mean in the Idaho case? From the video of one of the girls when they were like before they went home when they were getting something to eat? People were speculating it was Brian Koberger, but I never heard evidence of it, nor have I seen it talked about in the motions as regard to that video. That's very interesting, though. Rocket Cow says, let me put that up. I don't think you're a weirdo, though. That's not why I'm putting it up. Okay. Whoops. I am a weirdo who would opt for the firing squad. Seems like a more honorable way to go. Exactly. And quick, kind of violent, but yeah, I can't imagine being that firing squad. Like, is it automated? Like, do they just line up guns and then turn them on? Or does it have to be humans? Like, I have questions. I don't know about you guys, because I'm that weirdo, Rocket Couch. I have questions. How are they actually going to do it? Yeah. Teresa, so we are going to be on a break until the jury comes back, and then they're probably going to break for lunch. But today is supposed to be a half day for the jury, right? Exactly, Teresa. Welcome to my world of I have no idea what is going on about this. I'm enjoying chatting with you all, though, as we wait, and we shall continue to wait. And I'll stay live until my live stream goes down that I'm using for the feed. And even if that goes down, I will check with the other live streams before I go down for it, before I bring it down anyway. Exactly. Stand up and face your end rather than dying like a science experiment. It does seem more honorable. It makes for a better ending in a motion picture, or for reading in a book. Yeah. You finally caught up, Teresa. There wasn't really much. She said nothing. How frustration was that? Like, they did not say what those sidebars were about at all. You know, I would have liked a little bit of a heads up. But hey, the court doesn't care about Little Bear. They don't care about me. They don't care if I'm confused. Yeah, they don't care. They're just doing their thing. They're all out traveling. They're having a nice little outing. Yeah. Yep, I don't see them saying much. Yeah, so they had left. What time was that post? 23 minutes ago. So they left to get on the View. They're probably just about getting there now. I would imagine they'll be there. They've only got to look at a very little small area in the vehicle. I can't imagine they would be there more than a half hour. And they're on the way back. So I would say within the hour. Trying to think what else I had on Lori Vallow. Oh, I do. I do have something on Lori Vallow. Oh, there was something filed in regards to by the state. In regards to the Brendan Bardot case. Hold on one second. Let me get back to it. Okay. So basically, let me just get this at the right view. Okay. Trina K. filed state's notice of intent to use defendant's other acts to establish conspiracy, premeditation, and or to establish motive pursuant to Rule 404B of Arizona's Rules of Evidence. It was sent to Judge Boriski on, I don't have a date here yet. The state of Arizona hereby provides notice that the state intends to use defendants' other acts as evidence of the conspiracy and or to establish premeditation and or to establish motive pursuant to Rule 404B of the Arizona Rules of Evidence. The state believes that this testimony and evidence is admissible to establish the conspiracy and premeditation, but it is filing this motion as it would be also admissible to establish motive. Okay, she filed this on April 11th. Pursuant to 404B, this motion is supported by the following memorandum of points and authorities. Memorandum of points and authorities. The defendant is charged with conspiracy to commit first-degree murder, a Class 1 dangerous offense that occurred on October 2nd of 2019. The state will use cell phone records, iCloud accounts, and witness testimony to establish that the defendant believed that the victim was dark and or a zombie, that the defendant conspired with Alex Cox and Chad Daybell to kill the victim, and that this murder was premeditated. The evidence that the defendant, Chad Daybell, and Alex Cox believed the victim was dark and or zombie will be used to prove the conspiracy, but is also relevant to establish the motive pursuant to 404B. Hold on one second. And that was signed by Trina K. And submitted and given copies to George Boreski, to Lori Daybell, and to Pamela Hicks, who is the advisory counsel for the defendant. Wow. So that's interesting. That'll be a little bit different in the next trial against Lori Daybell. AI firing turtle moves you up. Oh no, I haven't. Well, I actually Googled it, and when I Googled it in Google Maps, it puts the traffic notations in there. It is but I understand what you mean because it is I-95. So I understand what, it could be things. But usually with Google, they put all of that in if I ask for it, and I did. So it is said 14, 15 minutes, but who knows? It could be different now. I can actually put the actual house number in. And yeah, it's still saying it's calculating it in because it says it's less than 10 miles away, and it's giving it up to 15 minutes to get there. Currently, there's a little bit of traffic, so it's saying at this time, right now, it's actually 2 minutes longer. They're saying 16 minutes to get there. And that would be via Boston Providence Turnpike and Nepperson Street, which is shorter. It's only almost 8 miles. But obviously more traffic because it's taking longer. So you're right, Jen. Like those roads are crazy, Well, I'm happy that my little Google is actually taking it into consideration. And it just and the fastest route is via I-95 South, but it's actually keeps adding time to it. So you're spot on about traffic at this time of day. And of course, we're going to hear the streets that they mentioned because we're going to hear Chapman. Take Chapman. You have to actually go from Nepperson to Chapman. Chapman is how you get to Fairview. You have to turn off of Chapman there. So. Would they be able to use the car share lane? I hope so, since they're taking a bus. Yeah. Yes, Puff Bunnies. In that article that I sent there, let me just post it again for those of you that go back to Daybell. This article here, for those that came in after. At the top of this article, there is a video of the actual interview that she just did post her guilty verdict. So it's new. It's the same journalist who did the one that was going on right before trial. Boston traffic never. Oh, absolutely, Puff Bunnies. I should also note that you started typing in the Google search at the same time I was starting my truck. The clicking of the keys made me think it was from the engine. I'm so sorry, Jin. That must have been a little frustrating. Yeah. Yep. Yeah, she does. She does kind of creep me out, but she basically, the whole thing, from Lori Vallow Daybell's perspective, from what I understand in her interview, she feels that the justice system is skewed against the defendants, that you're not able to put on a defense, that she doesn't find it fair that the prosecution gets to put on a case, limit what she can do and say, and then put on a rebuttal case to just slam you anyway. And she was quite indignant about it. She was quite upset about not being able to put anybody on for her witnesses. She was asked directly, why didn't you put your witnesses on the stand? You had your mother, you had your sister, you had your father, you were going to cross-examine your brother again. Like, you had these witnesses. And she said, yes, but there were things that were pertinent to the situation that we weren't allowed to talk about. So why would I put them up there? Like, they stopped me from talking about it. Now, she always gets to this point and she refers everybody to the interview or to the discussion she had with her son. I think it was on the phone from jail, in regards to what happened to his sister, Tylee. And she kind of infers in this too, that she actually says Tylee took her own life. I heard her say it. But then she backpedals and she doesn't want to give any information because she says she's coming into another trial and she's still up for appeal. Basically, even if that, she had said that in Idaho. Well, basically the condition of the body, if that is true, that Tylee did that, she was trying to say it was because of everything that happened with Charles Vallow. She put it together in that interview that this was the catalyst to all of the bad things that happened going forward. I think she's making Tylee into a scapegoat. If Tylee did take her own life, it just doesn't fit with the condition of the body based on what they did to that body, her body. I don't mean to refer to Tylee as a body, but for me, it's easier when I consider the fact that they burned it, dismembered it, buried it like an animal, instead of giving her the grace and consideration she well deserved, as every human does. It was disgusting what they found, to the point that we still have officers all this time later who, when they have to talk about it, as they did in the Chad Daybell trial, were emotionally affected and actually were able to tell the jury how it affects them every day still. It's one of the most horrific days of their lives in working as law enforcement. And that stuck with me. Ray Hermosillo was the lead detective in the Idaho case. Ray Hermosillo sat with Colby Ryan in this trial while his mother was convicted again. This case, that Lori Vallow Daybell case, has affected so many people. Lori Vallow herself has affected so many people's lives. And what really irked me was her bringing up the children in some kind of defense, and that they're in heaven, and then since she had a near-death experience, she knows what heaven's like because she's been there. So she's not worried because they are happy and content and in peace. And that's fine for Lori Vallow Daybell. Great. But now that whole thing could come in this trial. Her convictions. Now, when they say 404B testimony, they're not telling us specifically, will it be the 3 murders in Idaho, which happened around that time? Or will it be Charles Vallow? Or will it be all 4? It's interesting, huh? And will it also include evidence from the Chad Daybell trial and the information that he's sitting on death row? Alex Clark is dead. Chad Daybell's on death row for the same murders that you're convicted of. And we're going to get you for the attempted murder of your ex-nephew-in-law. Because Melanie was Lori's niece. Yeah, how dare they have rules about how to do things. I know. She's very entitled if you watch this. It was pretty unnerving for me. And then when she did go on, like if you get this far, if you can stomach it, and you get this far in the interview, you're going to hear her go on how she's going to be helping all the inmates, because all these women have not been able to come to trial, have not been able to defend themselves, develop a defense case, because the whole system's skewed against them. She's going to help them. I don't know. It kind of like really, I have to admit, it really annoyed me. It really annoyed me. Okay, so today there's also a lot of movement in true crime on some other cases. Let's see. Sean Combs and Luigi Mangione have court hearings today. Luigi Mangione in the federal court in regards to his arraignment on those very serious charges. So remember, the American government has come out and said that they want the death penalty for Luigi Mangione. They are the ones that are insisting on the terroristic charge and up the charges in New York state case. Now, who has precedent in jurisdiction at the current time? The actual charge, the offense, or the actual murder of the CEO of United Healthcare, Brian Thompson, was in New York. So they have jurisdiction straight out, right? That case is going to go first. That one is being directed pretty much by the federal case. The federal case is limiting where Luigi Mangione can go. It is actually preventing him from going to Pennsylvania, where he has other charges, where he was captured, arrested for extradition to New York. Was found to have some things on him, so to speak. There were filings in that case against illegal search and seizure in regards to his rights being violated, that they actually physically made a barricade that he couldn't go past, even though they told him he was free to leave and he didn't need to talk to them. And did not get Miranda rights. Like, it was like one of those, say this but do that situations. And, well, there was a really good filing done by defense attorney Mr. Dickey in Pennsylvania on that. Still waiting to hear about that. That's kind of in stay over there. But Luigi Mangione is not being transported by the federal government to Pennsylvania for any of those hearings. Well, it makes for a problem. In regards to the state case, which is going to be tried first, it's a problem that he's in federal custody because he is much more limited and restricted. He's not able to have any real conversations with his attorneys before or after. They bring him in just in time and they bring him right back out. It's not like, not that it's ever easy when someone's in custody, especially maximum security based on the crime, to actually meet with them on court days of hearings and things like that. But it's extra inhibited in this case. Karen Agnafilo in this case is the defense attorney for New York cases, and she is pressing that this is overcharged. She's pressing suppression of evidence, of delaying and turning things over. She made a filing of complaint in regards to evidence that was shown in an interview by the police commissioner and the mayor, where they read excerpts from the so-called diary that is supposed to be part of this manifesto, but have not provided said diary and or notes and manifesto to the defendant. That's an issue. She's also going to push against the charge of terrorism, stating, in my humble opinion, rightly so, that the whole thing is a political move in that it serves the purposes of certain people, but definitely not justice for Brian Thompson and or a fair trial for Luigi Mangione. Let's just say that. I'm on the side of fair trial here. I feel for the victim's family, but I don't believe in overcharging just because of sensationalism or that there's a damn election going on in the area. But hey, that's me. I think it's political. When I look at the fact, when they did the perp walk, and that is like when they're arrested and they have to come in for their arrest, or they're bringing them from somewhere for extradition, and to compare it, both Luigi Mangione and Brian Kohlberger were extradited from other states to the state that they were facing charges for. They are usually in custody at the time, and they are wearing ankle cuffs and cuffs on their wrists. They're usually in mandated state jumpsuits, from the prison system, and they usually have federal marshals and other guards with them. But I bring this up in regards of comparison to the perp walk, we would call, of Luigi Mangione versus Brian Kohlberger. Brian Kohlberger, accused in Idaho, extradited from Pennsylvania on 4 charges of aggravated murder in the first degree, with a deadly weapon, while committing burglary, an extenuating circus and aggravating factor. His perp walk consisted of 5 officers of the court or judicial system in some way, whether they be federal marshals, local marshals, state troopers, 5 people for 4 murders. Luigi Mangione consisted of, think, upwards of 18. The mayor, the police commissioner, they were there when he got off that plane. They were there. The media was there. There were so many officers surrounding him for one murder. For one murder. What did they think he was going to do? I mean, it's definitely looking prejudicial. It's definitely looking very political in some of the charges and things that they're doing. It looks manipulative, and it doesn't seem fair. And I'm not going to say that this killing was justified. I don't think killings of any nature are justified ever. Let's just make that clear. But I do believe in the justice system, in fair trial, and it doesn't look like an opportunity for one is going to exist if they keep up these shenanigans. And that ain't right. That ain't right. So, Luigi Mangione is going to be a very politically based case, all 3 of them. But anyway, he has his hearing today. Sean Combs has a status hearing in regards to his trial that's coming up in May. We're going to be busy in May also. Quite a few of the May trials have already been moved. Paul Canero here in New Jersey that I was following, that has been moved to September 8th, I believe. I have to double check on that. Also, the case of in the Tupac murder, Dwayne Davies' case was also extended. So we're not going to see him go to trial in June, in the beginning of June, the end of May. Nope, not going to happen. He's actually saying he wasn't there now. I think I reported down that. I have a playlist for all of these that I mentioned. There's a playlist for Kohlberger. There's a playlist for Luigi Mangione. So that when I do cover them on those multi-case episodes, that they hit the right playlist so you know what you're looking for. And I can't say I do it every single time because a few have slipped through, but I try to timestamp or when I'm talking about each case to make it like if you're looking for a particular one, you can just go right to it. If anybody ever sees one of those videos without the timestamps, if I missed it, shoot me a note on the back of the video, because I will go back and timestamp it. I think it's important for people. It makes it easier. I'm not into frustrating others if I can help it. Was the perp walk for Luigi or Eric? I saw Eric, even the charges. You mean the mayor? Yes, the mayor of New York there? Yes, his charges are dropped, actually. Yeah. And the charges have been dropped. Yes, they have. And he was under investigation in going to be charged at the time. And I think it was a big whole PR thing, perhaps even the interviews on TV. I don't know. But I do know he's front and center all the time with anything to do about this now, which most politicians would be if it happened in their state or their city. But I get it. The mayor, yeah. The perp walk was actually for Luigi, but it had another perp or alleged perp there at the time. Maybe it was leading him, showing him what to do. Very funny, Jim. Yeah. Trying to think what else. Oh, Courtney Clenny has a hearing on the 30th. Now, her hearings have been rescheduled quite a bit lately. And there was a lot going on in that case. Remember, the prosecutor stepped down because he was actually listed that they could question him in regards to that information that they had access to, some private emails between the attorneys and Courtney Clenny's parents. When all of that went down with the laptop, and the laptop charges have been dropped on both sides, dropped against Courtney Clenny, dropped against her parents. All that is fine. But there still was the fact that the prosecution had access to things on that laptop, which gave them access to all of the emails between the attorneys and Courtney Clenny's parents, who at the time were paying the attorneys and arranging for, or possibly have to arrange it for bail money and etc. And actually, the attorneys in that case for Courtney Clenny did great arguments to the judge in regards to it doesn't matter what was in those emails. I marked them private, that this contained, my work product, my attorney work product in there. And she won. She did. Because although there was no expectation of privacy, because there's no attorney-client privilege between the attorneys and Courtney Clenny's parents. I mean, there are some rare circumstances that would exist, especially if they're paying for those services. When they were paying for those services with Courtney's money, they were actually just making the arrangement on how to use it and how to get access to it, because they are helping with her with her finances while she was actually locked up. And that testimony came out from Kim Clenny in the bail hearing, in regards to how he was helping her with the money, where she spent it, whatever, and this and that, because of the differences. But I hope that this one actually goes forward. Perhaps we will, the prosecuting office in Miami-Dade County is not really too concerned. They are still going forward with the case. They will just assign another prosecutor to it, and they'll get up to speed. But I would imagine that the hearings being moved continually is part of that process, the delay that's necessary for that attorney to get up to speed. That's good. We don't have a trial date for Clenny that I'm aware of. I'm just taking a breath there. I'm trying to think of another case to update you on. I have a lot of movement. We're still waiting for determinations in the Babylon 5, the body parts case, rather, in Babylon. Not the Babylon 5. The 5 would be in the missing Kansas mom's case. looks to be like 2 guilty pleas entered, or at least Cora entered guilty. Paul Grice and Cole Twombly probably have just released their speedy trial. I do believe Tiffany Adams in that case also didn't want the preliminary hearing, so she has released her rights to timely trial, also speedy trial rules. Only Ted Collum went forward. There was enough evidence, they said, to definitely leave it up to a jury to decide what he's guilty of. So that went forward. And now we're just all waiting to hear whether Paul Grice has actually stated guilty. And we know he's going to be taking a witness stand. In the Babylon body parts case, we did have 2 not guilties except termination, and they were to be determined. Their sentencing is supposed to happen in May. We also have hearings coming up for the other 2 offenders who did not entered not guilty and are going forward with the status hearing on 2 preliminary evidence in waiving for a speedy trial. In Rex Harriman, the Fry hearing of the DNA is continuing. There are more expert witnesses, and then, of course, Michael Brown, the defense attorney, will be able to present witnesses opposing the new technology from Steer Mix out of New Zealand that actually was able to. Oh no, that's Paul Canero's case. This is actually about genotyping, which is a step more sophisticated for non-root hair type DNA evidence or decomposing or breaking down evidence that is older in regards to analyzing it for DNA. And the actual technique that was used to shore up and further add to the probability percentages. And I say that specifically that it was used to firm up those things because in this case, Ray Tierney in the state's office did use the traditional mitochondrial matches and testing to go forward with that. So they have that as the backup there. That's already been done. That, of course, has been done throughout cases all in New York, and there's really no contest there. But to make it more specific, to instead of just family members or probabilities, they wanted to use this other newer technology that has not been used in the state of New York. And so they've been putting on expert witnesses in this Fry hearing. And I think I told you guys during the last update that they actually used a dinosaur from a Jurassic Park clip with this kind of comparing the process of this new technology, which is not necessarily new. It might be new to the court of New York, the state of New York courts. What it has have some scientific, some science community references and being used and has been used in other areas, on the record. So they do have that all going for it. But New York has to get it in, But they do have the backup DNA testing to go with it. This is all in regards to hairs that were found on the bodies of the Gilgo Beach murders. And that also an update on that case for the Gilgo Beach. The body of Peaches, the real name of Peaches, and further confirmation that DNA says that the baby is hers, that is her daughter, have been confirmed. Their names have been released. The family members did a press conference. There was a statement made the other day. Well, I don't know about any ties to Rex Harriman at this time. Not listed, not indicted to date. Well, to have the remains that were found in the name Peaches being given to this person was because of the tattoo found on her leg. But to have her identified as who she are and to put her family at rest that they finally know what happened and she's no longer just a missing person. Well, that's very sad. That's very sad. But for identification purposes and for people to move on forward and heal a little bit, for that, I'm glad that that was done. And now I have a quandary. I'm going to have to put music on for 10 minutes because I need to take a break. I need to go make some coffee and I need to use the loo. Very European way to say, well, I've got to go use the facilities. So take a break for a few moments. I am watching. I'm going to keep my phone with me with it up and watch that little picture where the live stream that I'm bringing in comes in. Because if they go live, like I will be back here in a shot. Like since I'm not on camera, I don't have to worry about my hair being messed up or anything else that's going on. But I am going to put something on for just a couple minutes. It's not going to be very long, I promise. But I just need to take like 10 minutes at the most. All right. So let's listen to a little of. We'll put Wrecker's Claire's theme song on from a couple of years ago that he wrote for my channel when we first met. Here we go. Okay. I just saw the feed go back to the fan. I don't know why, because they're not saying, but there's hope. There's hope. Okay, let's just see. Let me go back to this. Let me just add it back. Oops, wrong. Where is the... There it is. That one. Okay. I don't see anything on the other feeds going back to the fan, but Boston was this is NBC Boston 10. And they actually had somebody reporting when they actually were going, when they actually arrived at 10:10. And they are expecting that they are going to come back to the site, from the site to the class, to the courtroom. So, yep. Let me just take that banner off. There we go. Well. But look at that. It's not spinning, though. The fan is not spinning. It's like a picture of the fan. Or the fan is off. Do you think they turned the fan off? Like, wait a minute. Hold on. All right, let me come back to this one for a second. I need this. That's making me crazy. Okay, NBC. All right, let me just tell you what they are saying now. Okay, this is from NBC 10 in Boston, and they are saying that we're hearing that the jury view has just concluded, so we're putting the courtroom feed back up in anticipation that the jurors will return to court at some point this morning. So this is like they're waiting too. They're not sure either. Neither is Law and Crime is saying that the bus has arrived. Brennan and Yannetti are among the lawyers present. Like that was there at the site. But currently, they're not reporting whether they're back, but they are showing a banner that the court is on a jury view and testimony will resume after. And they're showing like little comments from Twitter here and there, but they're all old. They're the ones that we talked about before, about them reporting for this view, they're only going to 34 Fairview, and that the Lexus is parked in front of the house so that they can see it. In the morning, they were expecting testimony before the jury view. That's what was reported by several reporters last night at the end of it. And it's what we heard in court, too. You know, well, we'll see. I mean, they can come back or not. But the fan isn't moving. That's not a good sign to me. Like the fact that the fan is not moving for me, it means not a good sign because, well, wouldn't that be like the courtroom is shut down? I don't know. I know. So I'm back. Oh, thank you, Turtle Wolf said, go powder your nose. Like, thank you. I'm back. But I'm not sure. I'm not sure what's going on. Like, everybody's guess is as good as mine at this point. If they arrived at 10 after 10, it is now only 11 o'clock. Court usually goes till 12 or 12:30 or for the lunch. So they would have a little bit of time. If anything, maybe they'll discuss motions. Maybe they'll discuss what's going to happen Friday with Arga. I don't know, but I would like to hear something, you know. Okay. Let's just see if there's anything else coming up from any of the other reporters that are out on the socials. Mostly people arguing about the buffer zone, you know. They're now loading the Lexus. They're taking the Lexus back, so like the jury has left. They have left the scene. For those of you that have X, here's a link to somebody who was there. This is from WCV Boston. Bynick, Mr. Bynick, a reporter there. But they're saying that this year, like, because they did have a view last year, and the Lexus was also in front of the house, but this year they brought it closer to the mound where they where the body was found. So instead of it being near the driveway like it was last year, it's actually, well, it actually he's showing, like, at the time that he is doing this report, which was a while, like just a few minutes ago, they're actually removing the Lexus now. So the jury's on their way back for sure. I'm pretty sure. I'm trying to look at the rest of the feed to find out if those people are just journalists. It does look like it could be the jury. The Lexus is being removed. They could be finishing up and they'll be on their way back. That would be interesting if we get any kind of testimony today. Or I wonder if they're able to ask questions. They weren't supposed to have a lot of interaction with the attorneys, only in direction on what to look at from their opening statement, so to speak. Let me see what he says in the beginning. I do believe that in that clip there are no jurors because they would not be able to show them. So I don't see the bus. So I do believe they've left. And the fan is on. Okay, wait. All right. The fan is spinning. How did I miss that? I'm so excited. I can't believe I'm sitting here excited that a fan is spinning. But yes, this is my life. I am actually excited that a fan is spinning. The jury view is over. It wrapped up at around 10:40, which was 20 minutes ago. Karen Leeds' Lexus was being removed back. It's from another reporter from Boston area. Another link to give you, but it doesn't help you unless you have X. Although I think on a PC, you can still, even if you don't have an X account, see the postings. They don't offer any new information, though. It's really just the scene. and the Lexus being loaded on. While the jury was there, they would not be able to actually report anything because they are not allowed to have any pictures of the jury at all, you know. Well, this one I'm definitely going to start getting the notices on her because she's right there. She's in the courtroom also. Her name is Katie Beno. She's from NBC 10 also. Oh. Well, it's been a weird morning for sure. Oh. It would be, oh, now the fan is not going anymore. Wait, was that just to tease us? Good morning. You know what? There's not much to catch up except for me just like talking about other cases, Mandy, because they've been on the jury view. I'm only keeping the feed live because it was rather confusing this morning. They came in, they did sidebars, they didn't tell us what was going on. Then they did the jury view. And that is a little different than what was said yesterday. They said that we would have testimony first. So I don't know if something happened with their witness. I don't really see any reporting on it because basically all the reporters were not in the courtroom because they're all getting ready for the jury view. So the courtroom was practically empty. I did not see the Reed family. We saw the O'Keefes. The courtroom looked really strange, like almost empty. They were on sidebar twice for extended period. I think it was more than 20, 25 minutes. Then they bring the jury in and announce they're going to jury view. And then they do opening for the jury view from both Hank Brennan and David Yannetti. And they both talked about what they should look for and what they want to concentrate on. Then they drove to 34 Fairview. That happened at about 10:10. They got there. They left before that. I searched it, and it takes about, with traffic and everything at the time, because Google was telling me the traffic at the time, it should have taken like 15 minutes to get there. They were there. Now people are showing reports afterwards saying everything was over with at 10:40, showing the Lexus and the house and all, because they couldn't actually show any reporting while they were there because jury members were there and they can't have any accidental pictures. So I do have one of the live feeds up for the local news that I've been using, and they put the fan back up thinking that the jury may come back in because it's not lunchtime yet, so the day isn't over. Maybe there was just a delay in the morning witness. Maybe they still are coming. It was anticipated to be the expert in regards to the blood analysis for the alcohol measurement of Karen Reed, the testing that was done. It's fan footage, and some lady yapping. I'd be the lady named Bear up here just yapping away about other court cases and updates since I can't do my weekly update. This will actually be a brief weekly update, everyone, that you didn't get Tuesday about cases that are going on. We talked about current hearings and some of the other cases that were occurring, some of the delays, some of the interesting hearings that are going on, like the Fry hearing in Harriman's case from the Southern District from New York. Yeah. And the fact that there's a Luigi Mangione hearing today and also a Sean Combs hearing today. And here we are sitting looking at a fan in the Reed trial. Live trial with a fan. But I am a fan of the fan. You're right, Couch. But it was spinning, and now it's not. And that's my update. That is my update on the Karen Reed trial. Fan was stationary. Fan spun for a while. Fan went back to stationary. Stay tuned for a more episode of What Will the Fan Do? Yeah, I've lost my mind. I need more coffee. I don't like being out of the loop. I have no idea what's going on. I have searched the socials. It's everybody's guess because there weren't enough reporters in the courtroom to listen to the sidebar or to figure it out. And no one's saying anything. Bizarre. Mandy, did you catch the interview of Lori Valadebel post verdict? My, was it fun? I don't see anything yet. Well, I would just like to hear something from somebody. Sorry to be so quiet. I'm looking at the socials at the same time. I guess we're going to find out there. Hopefully, we'll see something very soon. I'm still scrubbing on the socials everywhere. I'm looking on Facebook. I'm looking, checking on X. Seems to have the most on Karen Reed, though, to be honest. Like every day. They are making some notes about the yard being tiny. The Lexus, the light had already been removed. They did close off the street again for the opening of Fairview, so that people were not going to be able to get in while they were there. But for all honesty, they were there and done within an hour, so. The media did have to stay 100 yards away. They don't want them to have any pictures of the juror members or anything. You know, they waited on the bus 100 meters away. Once the bus left again, they were able to go and take pictures of the property as the jury saw it in the Lexus. And then, of course, the law enforcement was there to load the Lexus back onto the trailer and to remove it. Well, most of the jurors that attend daily were there at the site already this morning, so they must have known. Now, there are still some, reporters at the site from like 13, 14 minutes ago, still taking pictures of the property on the places they weren't allowed to while the jury was there, just to try to convey what the jury saw. Pictures of the house, the Lexus in front. This particular link that I am going to share it's from X, and it has actually the Lexus there. I hear noise. Oh, wait. I hear noise. Do you? Curious. Is it the janitor or is it the judge? Oh, sounds like judge. What is going on?
Court is back in session and may be seated.
Yay! Excuse my
Who is
enthusiasm.
your next witness?
Your Honor, the Commonwealth called Dr. Gary Fowler to the stand.
Thank you.
Thank you.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Sure.
Good morning, Doctor.
Good morning. Good morning, Laura.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Dr. Gary Fowler, F as in Frank, A-L-L-E-R.
And what is your occupation?
I am a physician pathologist.
And where do you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago. I am the chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any capacity similar to that prior to working at Good Samaritan?
Prior to Good Samaritan, I worked at the Kearney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Kearney Hospital up until actually closed 6 months ago. So I've been on staff at Kearney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
And then where did you go following your residency?
And right from residency, my first job was at Kearney Hospital, which I previously mentioned, so 1996.
And doctor, are you board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is something we need to show that we are actually qualified to perform the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
First, in just general terms, if you could explain to the jury, what is pathology?
Pathology is, well, there are two basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of, somebody has a cancer or if somebody doesn't have a cancer, benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist, is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
And so the time that you worked at Good Samaritan, did that cover the date of January 29th, 2022?
Yes.
And again, what was your title and what was your job at Good Samaritan in the month of January 2022?
I was the chief of pathology at the time and laboratory medical director.
What did you do as the laboratory medical director?
Laboratory medical director, basically, the laboratory medical director is responsible for the ultimate quality of any, either whether it's a biopsy, somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency for all the lab techs and phlebotomists and even pathologists. So basically the laboratory medical director, if something goes wrong, it's ultimately his or her fault.
And the lab at Good Samaritan, is that lab accredited?
Yes, it is.
And by what body?
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years we have a laboratory inspection. They don't tell you when they're coming. They will give you a 3-month window and they'll come and inspect you to make sure we have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology, the CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was your laboratory at Good Samaritan, was the accreditation up to date on January 29th, 2022?
We were accredited, still are.
Now, in Good Samaritan Medical Center, when a blood test is ordered, what types of things is the lab testing for?
I think the most common tests that are performed when you go and you have your blood test is one is chemistry, a chemistry test where we sodium, potassium, chloride, glucose. We also a common test is a CBC, or a complete blood count, where we look at your red blood cells and your white blood cells and your platelets. Those are the two most common tests.
And why is blood testing ordered in the course of medical treatment at a hospital?
When you're admitted to the hospital, usually you're sick, so the physician is usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor take care of you. You know, if they look at a BUN and creatinine, maybe if they're elevated, you either could be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general, a good look at the patients to see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
Basically, what I just said. If there's nothing, if the results are normal, that sometimes helps too. Rules things out if they're normal. If they do a CBC and look at the hemoglobin and it's low and patient's anemic, maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider, the clinician.
Now, with reference to alcohol, does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that assist medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe a patient has ingested maybe drugs of abuse, so they'll test for alcohol to see, one, if it's positive, and if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do. And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
May I approach the witness, Your Honor? Doctor, I'm placing before you two sets of documents. Just ask you to review those generally and look up in the And do you recognize what those are, sir?
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Okay. The first one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's bracelet. So one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details what to do next, including finding the veins, cleaning the site. It has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach again, Your Honor?
Yes.
Your Honor, Commonwealth will seek to introduce in the minutes the next two exhibits.
All right, thank you.
Your Honor, for the record, it would be the patient preparation for specimen collection, the next exhibit in line. And the ETOH policy would be the next exhibit number 37. Now, doctor, what types of precautions are in place at Good Samaritan with respect specifically to alcohol testing in the blood? Or I should say taking the blood sample from the patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab, because potentially when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and every hospital should have the same policy, where we use a swab that has no alcohol. We call them a moist towelette. That's what we refer them to. Also, in the emergency room, my supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So,
when were the alcohol swabs removed from the emergency department?
It was before my time.
Fair to say prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained, competent, and know what to do when they draw a patient's blood.
What kind of training do phlebotomists receive at Good Samaritan?
We try to hire phlebotomists who have been trained. It's just easier. So they can have a high school background, but if we train on site, they just need to be trained on the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomists at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So with phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing, and it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their own, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA, and 6 months from that, 1 year from the start date, is another competency. And then after that, it's annual thereafter. And that goes for phlebotomists, and it goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room, because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initialed and with the phlebotomist's initial and date and time. That blood test will then be sent to the lab, In this case, the blood was drawn in the emergency room, so it gets packaged into a plastic bag and sent in a pneumatic tube up to the laboratory.
And once it's sent to the laboratory, what happens with the sample from there?
Once we receive it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube that has lithium heparin in it. It's an anticoagulant. We don't want the blood to clot, so that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. The centrifuge is a machine that spins the blood rapidly. We spin it at around 3,300 RPMs, which is pretty fast, rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologist will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries, as well as alcohol testing. It goes onto a machine. All the testing is basically inside of a black box. And the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine, it knows what test to do, and it will perform an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So ROCHE, Roche, and Cobas, COBAS.
Thank you, sir. May I approach on?
Yes.
Doctor, showing you another series of documents. Again, if you could just look at that and look up when you're finished. Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And sir, is there an indication within those records as far as the date of treatment for Ms. Reed?
Yes, there's a bunch of dates in here.
As far as the treatment is concerned, sir?
Yes.
And what is the date of treatment?
Oh. 1/9/22.
Sorry, is that 29/22?
That's what it says on this. Admit date, it says 1/29/22.
Thank you, sir. That's fine. Doctor, if I could direct your attention further into the document to a previously tabbed portion, do you see any indication in there as far as a result for alcohol testing?
Yes, I do.
And with respect to that result, have you reviewed these records prior to today?
Yes, I did.
And if you could explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
And when was it taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So it was ordered at 9:03, and I believe it was 9:53. The results were in the computer.
And may I approach again, Your Honor?
Yes.
Commonwealth will seek to introduce and admit as the next exhibit.
Any objection, Ms. Little? No objection. All right, thank you. Exhibit 37.
Your Honor, may I return to the document?
Yes.
And doctor, what was the result of the testing for alcohol in the defendant's blood when it was taken shortly after 9 a.m. on January 29th?
93 milligrams per deciliter.
Thank you. Nothing further, Your Honor.
Okay. Ms. Little?
Good afternoon, Dr. Fowler.
Oh, good afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.9% of the time we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common, I think uncommon.
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
You testified earlier today that your lab is accredited by CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for Good Samaritan.
In fact, Good Samaritan has never been investigated or accredited by any forensic accreditation team to ensure that you perform all of your tests with the integrity necessary to support results in court, right?
we've never had the forensic accreditation, but we have very good quality lab results, which I could go into further.
But you've never been accredited by a forensic accreditation team,
No,
right?
no,
And the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
no,
Are you aware that ANAB is the forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court?
Sustained.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
yes,
And HSGC is the method that's used by forensic labs to test for blood alcohol content, right?
correct,
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
correct.
Can you briefly, just for the jury, describe sort of the difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out, all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood. That is the specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't, that's what when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test it on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, Doctor. Thank
Okay,
you. I'll
all right.
ask some additional questions
Okay.
to kind of clarify. And in a forensic lab, they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC, right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate, but at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that. That was my fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well, NADH is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that. Alcohol testing in the lab is correct.
I'll ask you some additional
Okay,
questions
sure.
about NADH and we'll
Sure.
get there.
Yeah.
So you can do this now, but let the doctor answer his question fully next question, okay? And the following questions.
Doctor, the higher the NADH in a patient's system, the higher the serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate, and almost when we compare our methodology to the Headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this, maybe some of you might understand the chemistry behind it, but we do, we take the patient's sample, and it's based on, we add, because when there's alcohol in the specimen, we add, actually, in the test system, alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system, it's alcohol dehydrogenase is in there. And what happens is when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's something that measures, a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers. And it's pretty accurate. It will monitor, it will tell you, it will tell the system how much NADH is produced, and that amount is directly proportional to the alcohol in the patient's sample. So it's a very, very accurate test, but there are some limitations that I can go into.
So wait for another question.
Okay.
Next question, Ms. Little.
Yes, so serum testing can be subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like headspace gas chromatography may have some limitations too, but I can go into them.
Next question.
What are some of the limitations of the serum testing?
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is icterus, which is high bilirubin. And the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols? And third is there's some unusual hematologic malignancies like Waldenstrom's macroglobulinemia that can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous, make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace, they make their own. So we have to rule that out. It's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid, those one is an enzyme, and the other one is an acid, that can cause false positives. Now,
If I could stop you there, doctor. I think those were the four that you identified, the four limitations: the lactic acid, the hemat.
Yeah.
If I could just
Go
ask
ahead
you
and
a
ask
few-
your next question.
If I could ask you a few more questions about LDH and lactic acid.
Sure.
You're aware, Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid or LDH actually forms NADH.
Lactic acid, I'll have to go into a little bit of chemistry. Lactic acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these ethanol testings back in the 1990s, when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
So in other words, NADH, studies have found, can actually be formed by certain biomechanical processes other than the presence of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, back to the anemia. I haven't read or heard of that.
That was stricken. That was not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study maybe 7-10 years ago.
Your Honor, there's no question pending.
You asked him about a study, if he was aware of the studies.
I asked, and that's a yes or no question. And he's...
All right, Doctor, we're going to hold that there for you and ask the next question.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which...
Can you do that again and slow down, please?
Sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels Through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'll strike the part of what the article held. Is he aware of the article?
No, I'm not, to be honest, no.
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29, 2022?
No, we don't, no.
And again, serum tests like the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Doctor, you did a number of other tests on Ms. Reed on January 29th, 2022. You tested for additional drugs, not just alcohol, correct?
Correct.
And all of those results were negative.
Correct.
Thank you. No further questions.
Okay.
Doctor, are you aware, I know your lab at Good Samaritan did not do this process, but are you aware through your training experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to a blood alcohol concentration of whole blood?
I'm going to allow it. The door was open.
Go ahead, sir.
Yes, I am aware. Yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol concentrates goes to, when it's in your blood, it goes more to the watery components of your blood. So when I described the process earlier, whole blood is before we spin it. And when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. So it could be 18% or 11% higher in serum versus whole blood. But we don't do it. That's what I read. I will defer that to the experts.
Now, doctor, you were referencing in your cross-examination about a study that you were aware of about 10 years ago or so regarding MS and alcohol testing. Is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has, it's an FDA approved test, and they have to do in-depth detailed testing before they allow any hospital to do a test. And they have listed levels of lactic acid beyond which the test would not be reliable. But the results based on this study of 600 multiple sclerosis patients two big centers in Italy and one in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, or slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center, the interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
No, I'll allow it.
The three main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. It hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical record, notice any interference or any reports like that in her record?
No.
Now, the testing that you're doing at Good Samaritan is in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
We have, you mentioned proficiency testing before. So all hospital laboratories accredited by the CAP or have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP, which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time, we're also able to look at results of all the other labs that participated in this proficiency testing. So we can look at different methods. We can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see, how do we compare? And we have pretty exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually, the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
And doctor, from your review of the defendant's medical records and the blood testing in this case, was that done in conformity with the policies and protocols at Good Samaritan?
We have policies in place to be followed, and there's no reason not to think that somebody didn't follow policy.
Thank you, sir.
Anything else, Ms. Little?
No questions.
All right, doctor, you are all set, sir. Thank you. Do you have another witness, Mr. Brennan?
I do.
Okay.
The Commonwealth calls Jason Becker. house over here.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Good afternoon, sir. All right, Mr. Brennan.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live in Canton.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to EMT school a little over 10 years ago and paramedic school.
Tell me a little bit about EMT school. How old were you when you started EMT school?
When I started EMT school, roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
Tell us a little bit about EMT school. What did it require?
EMT school is a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's about a little extended, 2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
Oh, I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and they send you to the fire academy, where you train to be a firefighter.
So you had EMT training, paramedic training, and then firefighter training.
That's correct.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir.
department, sorry.
Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to
The engine, correct.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So he was there to teach me.
So would Dan Whitley be the lead on the call and he would help you?
I would be the lead.
You would be the lead.
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for a Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
Okay. How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
And on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're unseen first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant, who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to who's in the passenger seat of that car, do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue, navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back in the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
Was she cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and Firefighter Whitley.
So you and Firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
Each patient's different, depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was calling dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
Were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no,
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean. She just kind of said it in jest because of the events that she went through. So she was, but then there'd be periods of which she'd be calm, and it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
I'll allow that. It came in.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Okay. Thank you. I have no further questions.
Mr. Jackson?
Thank you. I have just a moment, Your Honor.
Yes.
Good afternoon, Firefighter Becker.
Good afternoon.
When you first arrived at the scene, there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there?
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared?
They had already transported to the hospital.
Remind me, you were in ambulance two?
Two. I was ambulance 2.
Got it. You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door.
Correct.
Had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes?
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment?
Well, it's more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male?
Female.
So there are two females, one Miss Reed, one another female. Did you see any other civilian females out there?
I didn't see.
Okay,
But
so at least where you were, the contact that you had with Miss Reed and this other female, there was just two of them, not a third one.
from what I saw, correct.
Did you get the other female's name?
I not at the time. I did not.
Okay. Have you, by the way, have you since gotten her name?
Based on a conversation Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person?
Miss Carrie Roberts.
Okay. When you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did. Yes.
Describe that to the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
She had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did. So that kind of, in a way, ruled it out.
Okay.
No injury for me.
And you didn't indicate, you didn't notice anything about her that looked like she was physically injured, physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck.
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay. You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma as best you were trained at the time? Objection.
A little bit more of a foundation. I'll give it to you.
Sure. Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
Frequently.
Everyone's different though.
Understood. Obviously, everybody's got their own personalities and the way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yeah.
Okay. Did it appear at that time when you're interacting with Ms. Reed that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So hence the rapid speech, the repetitive speech, things of that nature.
Correct. For her, for the defendant, some people don't have rapid, repetitive
Understood.
speech.
I'm just talking about your observations of her at that time.
Yes, yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously of great concern to you and your partners when you're assessing a patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault. At the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
So I couldn't rule it out, but
okay.
I didn't think it was a huge threat at the time.
Understood.
But we couldn't rule it out. So that's why, we had to take her to the hospital.
Understood. I mean, you had a section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was before we started transporting. He was kind of in and out, trying to find more of, talking to the police officers, find more of a story of, what happened,
Okay.
why we're taking the defendant on a Section 12.
Once you and Miss Reed were in the back of the ambulance, firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam.
It's a good, yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that.
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse.
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You're aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there's certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those on a tape recorder, correct?
I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it's kind of for every call, we jot down notes on a notepad, just
Okay.
so, when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
I gotta, to be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on
Okay.
at the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer, as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes
Okay.
I write on the computer, sometimes I don't.
Or you might not have written anything down, correct?
Correct.
Okay. So in any event, you weren't taking down, even if you were taking notes, you weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right. You had previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly. The last words, it was the last conversation.
Okay, that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase "her last words to him"?
Yes,
were
I
in
did.
anger?
I did.
And that was at a hearing where you're under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
Grand jury, yes.
Okay. And the phrase that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said, quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
Okay, with this sidebar, like I'm not sure what that's about. It might be timing because of lunch, in a rebuttal. I don't know. Hello, fan. How you doing, Teresa? That's a good question. I am not sure. About the exact time. I think it's up to 3 months. It's a long one. I think it was 12 weeks. I'm not sure. I have to look. I have to go back and look. I didn't cover the first trial, so I don't really have a lot of the documentation up in organized for the first trial very well. I do know during the hearings there was a lot of talk about the length of this trial. In the Commonwealth, they actually shortened the time that they would need, but the defense lengthened it. So I think it turned out to be the same, if I remember the hearing correctly. Still not a fan of the defense lawyers? Maggie, you're not alone. Their tactics, which I know they have to do the best they can for their attorney, it's not for their client, rather, the defendant. It's not uncommon for them to attack methodology, the law, the process of the investigation itself. And it's just standard. It's how Alan Jackson does it that really offends me.
May I continue, Your Honor?
Yes.
Thank you. When you were recounting the conversation that Ms. Reed indicated that she was upset about, you also indicated, in addition to using the phrase her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
Yeah, I don't think he said that. I know you want him to say that. But it's not going to matter, Mr. Jackson. We're going to hear those phone calls in text.
Just a moment, Your Honor.
After midnight. I don't recall is an excellent answer, so that you can't be held to task for switching a word or whatever about your prior testimony. If you don't know exactly, then say, I don't recall.
Thank you.
If you don't mind, take a look at the top paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Okay. May I approach?
Yes.
Hmm.
Thank you, sir.
You got it.
When you wrote your report,
Well, then
you
don't.
indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct?
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
She said that.
Yes.
Correct.
Okay. Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she believed he ever received her last words to him?
There's no other details. There was no other details other than what she said.
Okay. But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay. In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him, being very angry on those missed calls, those voicemails? Did you put those two things together?
I did.
Okay. Thank you. That's all.
Okay, Mr. Brennan.
So when Ms. Reed told you that she was sad because her last conversation, her last thing that she had said to him was an argument, did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection.
Sustained.
You then were interviewed, weren't you? You
Yes.
interviewed on February 14th, 2022,
Yes.
and you referred to the fact that she told you there was an argument earlier in the night.
Argument early in the night.
And she was telling you this when you were speaking to her that morning.
Correct. Around 6 a.m. Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No,
or midnight?
I didn't know the time.
So his answer is he doesn't know.
You testified in the grand jury, and Attorney Jackson just asked you some questions about part of the statement you made to the grand jury when he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
Her last words?
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
This is page 81, lines 1 through 4. Please read it yourself.
Right here, sir.
1 through 4, please.
Yes.
Now, when you made that statement you were asked about in the grand jury, you didn't just say, like her last words, did you?
No.
You explained your memory to the grand jury?
Objection.
Ask him what he told the grand jury.
Okay. The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay. And did you tell the grand jury? So she
I'm going to see counsel at sidebar for a second, please.
This is getting a little contentious here just about when this so-called whatever statement she made about an argument. Does it matter if it was earlier in the day or later on? Both of those are coming into evidence. Like they are going to enter later the text messages from her phone in that she sent to him after they had arrived at 34 Fairfield. We've only seen so far. The jury has only seen the text messages for the discourse back and forth with both John O'Keefe and Karen Reed prior to them going out that night.
May I approach?
Yes.
So I'm showing you that statement that you made. That includes the last words. But there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh,
your
sorry.
entire
Sure.
statement, 1 through 5. And read that out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that was like her last words to him.
And so when you were speaking about her last words to him, were you referring to the argument?
Correct.
You testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
And at that point, did you think or believe that the conversation she was relating to you was about a voicemail?
Objection.
I'm going to sustain the objection.
Did you use the word again on May 3rd, 2024, argument?
Objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
Can I ask you to read your prior statement on page 10, lines 9 through 13?
Objection.
I'm going to see you at sidebar again and bring these documents, please. Bring all of it.
She's trying to be fair. Now, I do find it kind of ironic that the defense is objecting to prior testimony comparison being brought in when that is exactly the tactic they've been using to try to impeach witnesses on their prior grand jury or first trial statements. And we saw that repeatedly. But they're going to do what they need to, as they should. Mm. Just like we let anyone coming in say what they need to, as long as they're respectful. I don't think it's the point that Brennan's trying to make, that it's the method that he's doing it, the way the questions are formatted, that is allowing the objections to be sustained. Rocket Couch says, I'm thinking the defense team has clued into the fact that they've been going too hard on witnesses and won't want to switch up. Perhaps there's been a little bit of change in tone. There's been a lot of pushback. It could be true. I didn't see that message earlier. I just caught it now when I was going through looking for other comments from our drive-by. I'm not understanding, and granted, I could be missing the angle that they're coming from. But I don't understand why it's necessary, the difference in a message, the text message, the voicemail. And the point of the matter for the testimony is that Karen Reed was stating that she was upset because her last interaction with John O'Keefe was not what she wanted it to be. That whatever word she used, the paramedic understood it as to be they were in an argument. Yes, you may not know what time that was. We know that there were earlier text messages that show some discourse. We've also heard voicemails and text messages from later after the arrival at 34 Fairfield that were also seemed to be where she was upset and that an argument may have happened. She states she was upset because he never came back out to the car and she left and she was upset. Well, she could be talking about those last words too. I mean, either way, she was upset about the last things that happened.
May I?
Yes.
Thank you. Sir, when you wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant,
It was.
and you later learned from the defendant it was a person by the name of Kerry Roberts.
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
Objection.
I'm going to allow it.
So the defendant brought up how if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection.
I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. You know, all the friends are on Canton, and
Of course, they don't want this in. This would be the second time they reiterate that she was making snarky remarks about Carrie Roberts after she had gotten up at 5 o'clock, with her and was helping to look for John O'Keefe. It goes to making her look bad in character, and so I can understand why they're objecting. But it's already in, and this is just support that it was actually said. It'll probably be allowed because it is actually confirmation. But we'll see. Well, it's a little longer. Sorry about that. The phone was ringing. I didn't want it to come through. I mean, I understand it's frustrating everybody when they object, and like we know that statement is already in from Whitley, but if you look at it from the other side, if they feel they discredited Whitley enough, because they did attack, like that was an aggressive cross. They really tried to discredit him. The last thing they want is another witness coming and giving credibility to the statements that they just tried to tear down. So they're gonna try what they can. And I would imagine that Hank Brennan is fervently arguing that statement was already in. It's collaborative testimony. They were both all there together. If it just shows that she did say it and that it is a credible statement. We'll see. But anything like this that comes to character, it's going to be hard to overcome this kind of stuff. Impressions of the jury of the defendant's character is difficult. I think most lawyers would tell you about that. So of course they're going to argue hard. They already have these clips to deal with of Karen's own words. You also have to remember at the scene, she was obviously very frantic and upset. I would be arguing excited utterance. Like I would just like they brought up before that she's suffering an event. She just found the body of her significant other and has just learned he's dead, possibly dead or on the way to the hospital. They don't know if they brought him back. It's trauma. Emotional distress. Let's see what happens.
When you spoke to the defendant and she shared with you that her last words with her husband were an argument, why didn't you ask for more detail about that?
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get to the hospital safely.
And you were asked about trauma, and you said that you observed that the person may be in trauma, Ms. Reed.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything? Very briefly, you indicated that you were asked on redirect examination by Mr. Brennan, whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked. Yes.
Earlier in the night could have been 6 o'clock p.m.
Early in the
Right.
night. Yeah, correct.
Could have been 5 o'clock p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
You were also asked whether or not Ms. Reed actually specifically mentioned voicemails when she talked about those last words. And you said she didn't,
That I remember. Correct.
but she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained. All right. Jurors disregard that last statement. All right, you are all set.
All right. Thank you. Thank you guys.
Is this a good place to stop for the day?
If the court pleases, yes.
Jurors, we could do 6 minutes, but I think this is probably a good place to start. So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this morning, and I've told you other times too, that when you're out in that room waiting for us, we're in here getting work done to make things more efficient for the trial, especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it, let us know. And I guess the 4th caution is the same as what we're saying. Please be very careful with your social. All right, have a good weekend. We'll see you Monday morning.
All rise for the court, please.
And I'd like to see counsel at sidebar, please.
Oh boy. Okay, well, it's a sidebar. I don't know if she's going to come back with anything about the schedule on the record, but we'll see. It was quite interesting. I don't know. Oh boy, I don't know. So I'm thinking it'll just be a couple of minutes. I'm gonna bring this down for now. I'll just. Oh wait, I'm not gonna bring it down because. Here we go again. Okay. What was that? Okay, so everybody sat back down. I guess that was it with the jury leaving. It does appear that the news feed I'm using also thinks that she's going to come back on. So, and it was a very long morning with that long gap with nobody here. We were just going on and chatting. The testimony, although when it comes to the expert witnesses, when they're doing the science, that can be boring for some, but I found it fascinating, and I do like the way it was going back and forth. Really did try to get both sides, the defense in, the Commonwealth, were doing their best to get out of the witness the information they wanted the jury to have, but in a digestible manner, which isn't always easy when it comes to very technical information. I mean, we can all understand, right, that hearing that a medical condition can affect the results of a type of test is one thing. Hearing how it affects or to what level it affects that test is another. And that's basically, in a nutshell, where both sides were coming from. The only job of the defense is reasonable doubt. They don't so much have to present a case as dismantle a case, so to speak. Point out inconsistencies, point out problem areas, point out alternate authorities. That's the defense's job. And all these long sidebars are. Well, she did confirm with the jury we're going to have morning testimony on Monday, and then the afternoon will be the ARCA hearing and the voir dire, rather. So we'll have 2 streams on Monday, morning and afternoon. And while we wait, I will just tell you that I will be back tonight with the very first review and commentary of season 7 for Black Mirror. We're going to cover the first episode, Common People. And my co-panelist tonight is Mousy. And I'm very happy to be streaming with her. She's also a Black Mirror fan. And this new season is something. I am quite excited about it. So we have that to look for tonight after a nice nap. They're all being patient and listening. Well, they can't really hear. They can probably see how animated everybody is. I did notice that Karen Reed is going up for all the sidebars as much as possible. Turtle, I know you're not a fan. Yes. You know, it is difficult to see them aggressively. Like, I know that a lot of people were upset, myself and several people in the chat, that to aggressively attack paramedics who are there trying, doing the best that they can to save people's lives, are doing good in general all over, and then to be treated that way. But, it is part of their job, and they have one concern, and that's the defendant. But it does appear a little distasteful, But that's the game. That's the lawyering game. There's all many different styles, Believe me, I'm not condoning it. I'm not backpedaling on anything I feel about it for sure. I just don't want to, very early on in a trial to just be, one way. Either I am mostly pro the justice system in general, so I do tend to be more favored to the judges, as long as they're being fair. That part really fascinates me. And all in all, I mean, as much flack as Judge Cannone gets, I actually think she's quite fair. And looking into her record, she's not very overturnable either. She knows the law. Some people have expressed loudly throughout the socials that she's made missteps or whatever. But I really think she's trying to do the best that she can to balance the situations on both sides, as is her responsibility to navigate the law, to be the gatekeeper. And I think she proved that to me the most. I mean, for me, it really sealed the deal in the handling of the ARCA situation. When she found that in February, she had asked a specific question, it did not receive a full, honest answer. I mean, that's exactly how I look at it. They may feel they answered her fully, but when she finds out that there are checks and this and that and things that happened that she was not informed of, she did not receive the full answer she was inquiring about in February from things that happened in the first trial. So, what she did was put the defendant's desires first. Informed of her findings, informed of what she was going to put on the record. Spoke with Karen Reed and her desire to continue with her defense team regardless, knowing that it would make it very difficult on appeal based on anything the attorneys had done for her to say, inappropriate or insufficient legal representation or anything along those lines. And she went with it. And so she didn't remove anyone, and sanctions to date have not come forward. Not necessary at this point if they're staying on. It's not unusual for that to happen after anyway. After the fact. Several of the trials that we have covered, it happened afterwards. Masterson in particular. Even a couple of times in Amber Heard, the judge had actually mentioned it would be dealt with after the fact. It's a long sidebar, almost as long as the one in the morning. He's just too quiet. I don't even know what to say anymore. Does anyone have any questions? Has the state witness on the car data testified? Not as of yet, Tomcat. There is a hearing on the defense's accident reconstruction witnesses from the first trial, ARCA, on Monday afternoon. So far as expert witnesses, we've had the pathologist who did the blood testing. That was today. That was Dr. Fowler. We also had, I don't know if you call him an expert. He is from the Massachusetts State Police, but we had we had Officer Garino.
All right, we'll see you Monday.
Wow, that was that? We'll see you Monday. It's the end. Well, there you go. Sorry about that, but they just broke in. Say goodbye to the fan, everyone. Until
Goodbye.
Monday.
All right.
Margaret, thank you.
All right, there we go. That is the end of that. That's crazy. Yeah. So, but what I was saying was the experts. I'm trying to answer Tomcat. The Garino could be considered an expert. He works with the Massachusetts State Police, and he did the phone extraction, and he was entering in text messages and such, and talking about how the phones were extracted. So I guess it's expert testimony, and that was it so far. We are on witness number 11, but therefore Garino was counted twice. He's number 4 and number 9, because every time he sits, I say that's the X. Another witness, even though it's the same one. But that's it for today. Do you miss the fan already, you guys? I know. Should I give you another parting shot of the fan before we go out? There we go. It's still going round and round. The judge didn't sound thrilled But I don't think she like the objections back and forth, like they annoy her. I can tell. You know, she would prefer they work these things out, you know, without like having to do that. But you know, each side's going to do what they're going to do. But on that, it is better than the ceiling light. It's like I gave it an honorary thumbnail today too. In trying to work on my ARCA thumbnails for Monday. That should be interesting. And now that I know that they still do plan on having the voir dire of ARCA on in the afternoon, it should be pretty good. Oh, I'm sorry. You got another ad. I don't know why they come in the middle. They should only be coming when you come onto the stream. Like I don't have midstream ads. Like I don't have that option pressed. But I know that YouTube still, like last terms of service on ads and stuff that we got from monetized channels did say that there were some minimum ones they would be doing, but I'm not sure where they are. I'll look forward to this afternoon, you wonderful fuzzy mammal. No ads on Twitch side, just saying. Yes, Couch, say that a lot. Get me some more people over there. We need to get the affiliate going so we can do the emojis and stuff. It would be great, you know. Okay, on that, I'm going to wrap it up. There's no afternoon stream for the Karen Reed trial because they are dismissed for the day. And we will have a stream tonight, though, on Black Mirror. I'm going to toot my horn a little bit more and just tell you guys that is definitely something I'm really looking forward to. And I hope, let me just get that link up. If you're a Black Mirror fan, or if not, even, I hope you give it a view. And if you can't be there live, replay is always an option. On that, for the rest of the weekend, we have part 4 of the 50th Law that we are doing with Becker in that series to finish up that book of review and commentary on Conquering Fear. And then Sunday, we'll probably have our regular hang. So, and on that, thank you very much, mods, for helping to keep the chat respectful and cool. Not that we have many problems because you're all so great. Thank you for those of you in the chat with your questions and for keeping me company. And thank you to the viewers later that will view and hopefully comment with any questions or anything else that you'd like to talk about. Today includes a long intermission while they did the jury view. And so if you do play back, there's quite a bit of time that is time marked there, but it does include quite a few little updates on other cases that we're all following together. And I didn't time stamp each individual one because it was only a minute here and a minute there. But they do include updates on several cases like Mengione and Harriman, and even the missing moms of Kansas, Butler and Kelly homicides. Several cases, information in there. Paul Canero. So on that, have a great night, everybody. Or hopefully I'll see you later. If not, for those that are only covering the trial, we'll see you Monday. Bye.